The manila envelope sitting on my kitchen counter had fingerprints all over it, which told me someone had already pawed through my mail before it reached my mailbox in Naperville, Illinois. I'm Keith Thompson, and I'd been dealing with my homeowners association for 3 years now, but this was a new low even for them. I opened the envelope and pulled out a formal letter on cream-colored cardstock with the Pine Ridge HOA letterhead embossed at the top. The letter was signed by Patricia Morrison, the HOA president, who had made it her personal mission to make my life miserable since I'd moved into this suburban development. My jaw clenched as I read the opening paragraph demanding that I immediately provide the complete chemical formula for my ice melt product to the HOA board within 10 business days. The audacity was staggering. My ice melt formula wasn't just some homemade concoction I'd thrown together in my garage. It was a patented product that I'd spent 4 years developing, testing, and refining. I'd worked with chemists, filed extensive paperwork with the United States Patent and Trademark Office, and invested over $60,000 of my own money into research and development. The patent number was US 10,392,847 granted to me personally in August 2019. And the product had started generating real revenue through a partnership with a regional distributor just last year. I grabbed my phone and called my business partner, Marcus Chen, who handled the distribution side of our operation. He picked up on the second ring. "Keith, what's up? The HOA just sent me a formal demand letter. They want my ice melt formula." There was a long pause. "Wait, what?" "Your patented formula. The one we've been selling commercially. That's the one." Patricia Morrison apparently thinks she can just demand proprietary information because she doesn't like that my driveway melts faster than everyone else's during winter storms. Marcus let out a low whistle. "That's insane. She knows it's a real product, right? I mean, we've got it in 43 stores across northern Illinois. I don't think she's done any research. The letter treats it like I'm mixing up some dangerous chemicals in my basement, and she has a right to know what they are for community safety." I used air quotes even though he couldn't see me. "You need to call your lawyer. This isn't just HOA overreach anymore. This is intellectual property theft they are attempting." He was right. I scrolled through my contacts and found Daniel Reeves, the intellectual property attorney who'd helped me with the patent application. I shot him an email with a photo of the letter attached and asked for an emergency consultation. The next morning, I was sitting in Daniel's office in downtown Chicago, the letter spread out on his mahogany desk. Daniel was in his mid-50s with gray temples and reading glasses perched on his nose. He'd been practicing IP law for 26 years and had seen plenty of corporate espionage cases, but this seemed to perplex even him. "This is one of the most ridiculous demands I've encountered from an HOA," he said, shaking his head. "They have absolutely no legal standing to demand your formula. Your ice melt product is protected under federal patent law. The fact that you use it on your own property doesn't give them any rights to your intellectual property." "So what do I do? Just ignore the letter?" "No," you respond formally. "We'll draft a letter explaining that the product is patented, provide them with the patent number for their reference, and make it clear that any further attempts to obtain your proprietary formula will be considered industrial espionage and dealt with accordingly." Daniel leaned back in his chair. "We'll also include a cease and desist component. If they continue to harass you about this, we can pursue legal action." I nodded, feeling slightly better. "How much is this going to cost me?" "For the response letter and cease and desist, about $1,200. If this escalates to litigation, we're looking at significantly more. But honestly, Keith, I think once they realize they're dealing with federal intellectual property law and not just neighborhood bylaws, they'll back off. Daniel didn't know Patricia Morrison like I did. 3 days later, Daniel's formal response was sent via certified mail to the HOA board. I figured that would be the end of it. I was wrong. The following Tuesday evening, I came home from work at the chemical plant where I worked as a senior engineer to find a bright orange violation notice stapled to my front door. The notice claimed I was using unapproved chemical substances on my property and was being fined $500. Additionally, it stated that I was prohibited from using my ice melt product until I provided the formula to the HOA board for approval. I felt heat rising in my chest as I read the notice. This wasn't just overreach anymore. This was targeted harassment, and it was potentially damaging to my business. If word got out that there were safety concerns about my product, it could hurt sales and damage the reputation I'd spent years building. I called Daniel immediately. They just issued me a violation and a fine. They're claiming the product is unapproved and potentially dangerous. You have all your safety testing documentation, of course. The product went through extensive third-party testing. It's actually safer than most commercial ice melts because it doesn't contain calcium chloride or sodium chloride in concentrations that damage concrete or harm pets. The main active ingredient is a modified acetate compound. Good. We're going to need all that documentation. I'm filing an injunction first thing tomorrow morning to block the HOA from enforcing this fine or any related violations. We're also going to file a lawsuit for harassment and tortious interference with your business. The legal term gave me pause. Tortious interference. They're actively trying to prevent you from using your own legally patented product, which you sell commercially. That's textbook tortious interference with business relationships. If we can prove their actions have caused financial harm or damaged your business reputation, you may be entitled to damages. Things were escalating fast, but I didn't see any other option. Patricia had left me no choice. The next day, I took a personal day from work to meet with Daniel and go over all my documentation. We spread everything out in his conference room. The original patent application, the approval documents from the USPTO third-party safety testing results from an independent lab in Wisconsin, the distribution agreement with Marcus's company, sales records, and the marketing materials we developed. It was an impressive pile of legitimate business paperwork. "This is bulletproof," Daniel said, flipping through the safety reports. "Your product meets or exceeds all EPA guidelines for de-icing agents. It's been tested for aquatic toxicity, soil contamination, concrete degradation, and pet safety. You've got certifications I've never even heard of. I wanted to do it right. I knew if this product was going to succeed, it needed to be genuinely better than what was already on the market." Daniel nodded approvingly. "Well, you succeeded. Now let's make sure Patricia Morrison and her HOA board understand they've picked a fight with the wrong person." The injunction hearing was scheduled for the following Thursday. I had to take another day off work, which my supervisor wasn't thrilled about, but I explained the situation, and he was understanding. He'd dealt with his own HOA issues at his house in Schaumburg. The hearing was held at the DuPage County Courthouse in Wheaton. Daniel and I arrived early and set up at the plaintiff's table with our boxes of documentation. The HOA was represented by their association attorney, a woman named Jennifer Hartwell, who looked extremely uncomfortable when she saw the amount of material we'd brought. Patricia Morrison was there too, sitting behind the defense table with 2 other board members. a nervous-looking man named Gary Williams, and a stern older woman named Deborah Chen, who was the HOA treasurer. Patricia was exactly what you'd expect. Mid-40s, blonde highlights, expensive athleisure where that probably cost more than my monthly car payment, and the expression of someone who genuinely believed the world revolved around her opinions. Judge Michael Barrett entered the courtroom and we all stood. He was a no-nonsense type who, according to Daniel, had little patience for frivolous matters. That worked in our favor. Jennifer Hartwell presented the HOA's position first. She argued that the HOA had a legitimate interest in knowing what chemicals residents were using on their properties, especially products that could potentially run off into common areas or affect groundwater. She claimed that my refusal to provide the formula was suspicious and suggested I might be hiding dangerous ingredients. I watched Patricia nodding vigorously behind the defense table, clearly thinking the judge would side with them. Then it was Daniel's turn. He methodically laid out my patent documentation, the safety testing results, the EPA compliance certificates, and the commercial sales records. He explained that my formula was protected intellectual property that had been thoroughly vetted through multiple regulatory processes and independent testing. Your Honor, what we have here is not a case of a homeowner mixing unknown chemicals in his garage. We have a legitimate, patented commercial product that meets or exceeds all federal safety standards. The HOA is attempting to force Mr. Thompson to divulge proprietary business information that is protected under federal patent law. They have no legal authority to make such demands, and their actions constitute harassment and tortious interference with his business. Judge Barrett leaned forward, studying the patent documentation Daniel had provided. Miss Hartwell, was the HOA aware this was a patented commercial product before issuing the violation? Jennifer hesitated. We were informed after the initial request was made, Your Honor. And yet you proceeded with the violation and fine anyway. The board felt that even with a patent, they had a right to verify the safety of products used within the community. Judge Barrett removed his glasses and rubbed his eyes. Counselor, the Patent Office and multiple independent testing laboratories have already verified the safety of this product. The HOA doesn't get to override federal regulatory agencies because they feel like it. He turned to Daniel. I'm granting your injunction. The HOA is prohibited from enforcing the fine against Mr. Thompson and from any further demands regarding his product formula. Additionally, I'm ordering the HOA to remove the violation from Mr. Thompson's record. I felt a wave of relief wash over me. Patricia's face, meanwhile, had turned an alarming shade of red. Furthermore, Judge Barrett continued, I'm advising the HOA board to carefully consider their actions going forward. If I see this case again on my docket because you've continued this harassment, I will not be pleased. We walked out of the courthouse, and I felt like I could breathe again. Daniel clapped me on the shoulder. That went about as well as we could have hoped. The judge saw right through their nonsense. So that's it. It's over. Daniel's expression turned cautious. The immediate crisis is resolved. Whether Patricia lets it go is another question. Keep documenting everything. Save every email, every letter, every interaction. If she retaliates in any way, we need a paper trail. His caution proved prescient. 2 weeks later, I received another letter from the HOA. This one didn't mention my ice melt product at all. Instead, it claimed that my lawn was 1/4 inch taller than the permitted height according to HOA bylaws, and I was being fined $250. I looked at my lawn. It had been mowed 3 days ago and was immaculate. I'd actually measured it myself with a ruler just to be safe. exactly 2 inches tall, which was within the permitted range of 1.5 to 3 inches according to the bylaws I'd read cover to cover. I took photos with my phone, making sure to capture the ruler measurements. Then I pulled out the bylaws and photographed the relevant section. I sent everything to Daniel with a message. "She's retaliating." Daniel called me within an hour. "This is good for us, actually. It establishes a pattern of harassment. Document everything, dispute the fine formally, and do not pay it. If she keeps this up, we're going to file a much larger lawsuit." Over the next 6 weeks, I received 4 more bogus violations. One claimed my house numbers were not in compliance with community standards, even though they were identical to every other house on the street. Another stated that I'd parked my car improperly in my own driveway, with no explanation of what made it improper. A third claimed I'd left my garage door open for excessive periods in violation of aesthetic guidelines, even though I'd only had it open for 20 minutes while unloading groceries. The fourth claimed that my outdoor Christmas lights were still up past the permitted date, except they'd sent the violation in February, and the bylaw allowed lights through February 15th, 5 days after the violation was issued. Each time, I documented everything with photos, timestamps, and measurements. Each time, I sent the information to Daniel. The file was getting thick. "She's obsessed," Marcus said when I met him for lunch at a sports bar in downtown Naperville. "This isn't just HOA power tripping anymore. This is personal. I know. I think she's genuinely angry that the judge ruled against her. Patricia doesn't strike me as someone who handles being told no very well." Marcus took a drink of his beer. "How's it affecting business?" "So far, it's not. Our sales are actually up 15% this quarter. I think word got out about the patent and the safety certifications, and it's actually helping our credibility." I paused, "but I'm worried she might try to directly attack the business somehow." "Can she do that?" "I don't know. But at this point, I wouldn't put anything past her." My concerns proved justified in a way I hadn't anticipated. 3 weeks later, Marcus called me sounding frantic. "Keith, we have a problem. I just got a cease and desist letter from some law firm claiming our ice melt product contained stolen proprietary information belonging to the Pine Ridge HOA." I nearly dropped my phone. "What? It's insane. The letter claims that because you developed the formula while living in the HOA community, and because the HOA had requested the information, the intellectual property somehow belongs to them. They're threatening to sue us and all our retail partners for patent infringement." That's not how patents work. That's not how any of this works. I was pacing my kitchen now, my heart racing. The patent is registered to me personally. I developed it before I even moved to Pine Ridge. I can prove that with dated lab notebooks and prototype testing records. I know that, and you know that, but 3 of our retail partners just pulled our product from their shelves pending resolution of the dispute. They don't want to risk being caught in the middle of a lawsuit. I felt sick. This wasn't just harassment anymore. Patricia was actively trying to destroy my business, and it was working. I called Daniel immediately and explained the situation. There was a long silence on the other end of the line. "Keith, this has crossed a serious line. Filing a fraudulent intellectual property claim isn't just civil harassment. Depending on how they've documented this and what claims they're making, this could potentially be criminal fraud. What do I do? Forward me that cease and desist letter immediately. We're going to respond very aggressively. We're also going to file a lawsuit against Patricia Morrison personally and the HOA for defamation, tortious interference, and abuse of process. And I think it's time to bring in the authorities. The police, possibly. But first, I want to report this to the USPTO. Filing fraudulent patent claims is a federal offense. Let's make sure they are aware someone is falsely claiming ownership of your patent. The next few days were a blur of legal activity. Daniel filed a comprehensive lawsuit against Patricia Morrison individually and the Pine Ridge HOA collectively, seeking damages for harassment, defamation, tortious interference with business relationships, and abuse of process. The complaint ran 47 pages and included every documented incident of harassment, every bogus violation, and all the evidence of the fraudulent patent claim. The fraudulent cease and desist letter was particularly damaging to Patricia's position. The law firm that had sent it, when contacted by Daniel, immediately backed away from the case. Apparently, Patricia had hired them and made false representations about owning the intellectual property rights to my formula. When the firm realized they'd been misled, they withdrew from representing the HOA entirely and sent a formal apology to both me and Marcus. That left Patricia and the HOA scrambling to find new representation. More importantly, it left them exposed. Daniel also filed a formal complaint with the USPTO regarding the fraudulent patent claim. Within a week, we received confirmation that the office was investigating the matter. Making false claims of patent ownership was taken very seriously by federal authorities. But the most significant development came 2 weeks after Daniel filed our lawsuit. I was at work when I got a call from an unknown number with a Chicago area code. Mr. Thompson, this is Special Agent Linda Crawford with the FBI's Intellectual Property Rights Unit. I'm calling regarding a complaint filed with our office concerning fraudulent patent claims related to your ice melt product. My legs felt weak. Yes, that's correct. I'd like to set up a time to meet with you and go over the details of the case. We take intellectual property theft and fraud very seriously, especially when it involves attempts to misappropriate federally registered patents. We scheduled a meeting for the following afternoon at the FBI's Chicago field office. I called Daniel and he agreed to accompany me. The next day, sitting in a sterile conference room at the FBI office, I went through the entire timeline with Special Agent Crawford and her partner, Special Agent James Rivera. They took notes, examined all my documentation, and asked pointed questions about Patricia Morrison and the HOA board. Has Miss Morrison made any other attempts to obtain your formula besides the formal demand letter? Agent Crawford asked. I thought back. Actually, yes. About 2 months ago, she showed up at my house unannounced and asked if she could see where I made the ice melt. She said she was just curious as a neighbor. I told her it wasn't made at my house and that it was a commercial product. Did she seem satisfied with that answer? No. She kept pushing, asking where the manufacturing facility was located, who my partners were, things like that. I eventually had to ask her to leave. Agent Rivera made a note. And after the judge granted your injunction, that's when she hired a law firm to send fraudulent cease and desist letters claiming the HOA owned your patent. Correct. My business partner received the letter about 3 weeks after the court hearing. The agents exchanged a look that made me nervous. Agent Crawford leaned forward. Mr. Thompson, we've been investigating several cases of intellectual property theft related to HOA overreach. Your case isn't isolated. There's been a pattern of certain HOA management companies coaching board members on how to extract proprietary information from residents who run home-based businesses or who hold patents. We believe there may be a larger scheme at work. That caught me completely off guard. You think Patricia is part of some organized scheme? We're not sure yet. What we do know is that Pine Ridge HOA uses a management company called Premier Community Services. That company manages 43 HOAs across Illinois, Wisconsin, and Indiana. In the past 18 months, we've received 6 complaints similar to yours from residents of communities managed by Premier. Someone at that company may be advising HOA boards on how to misappropriate intellectual property, possibly for resale or licensing. I felt like I'd stumbled into something much bigger than a neighborhood dispute. Daniel looked equally surprised. "What do you need from me?" I asked. "Everything you've already provided, plus any documentation related to Premier Community Services. Any correspondence, any documents they've filed, any interaction you've had with their representatives. We're building a case, and your documentation is some of the most thorough we've seen." Over the next month, I compiled everything the FBI requested. It turned out that Premier Community Services had been deeply involved in pushing Patricia to pursue my formula. I found emails that had been inadvertently included in HOA meeting minutes, where a Premier representative named Todd Vickers had suggested that proprietary products developed by residents could represent valuable community assets if properly leveraged. The language was carefully worded, but the intent was clear. They were coaching HOA boards to steal intellectual property from their own residents. Agent Crawford confirmed my suspicions when she called 2 weeks later. "We've executed search warrants on Premier Community Services' main office in Schaumburg. We found extensive documentation of what we're calling an IP theft advisory program. They've been teaching HOA boards how to identify residents with valuable patents or proprietary information, and how to use HOA authority to pressure residents into surrendering that information. That's insane. Why would anyone think that would work? Because it has worked in some cases. We've identified at least 11 residents across their managed communities who surrendered proprietary information under pressure. Most of them had smaller patents or trade secrets that weren't worth the cost of defending legally. They gave in rather than fight extended legal battles with their HOAs. What happens now? We're bringing charges against Premier Community Services and 3 of their senior executives for conspiracy to commit fraud, wire fraud, and theft of trade secrets. We're also pursuing charges against several HOA board members who were active participants in the scheme, including Patricia Morrison. My heart skipped. Patricia is being charged. Yes. In your case specifically, she went beyond what Premier advised. The fraudulent cease and desist letter claiming HOA ownership of your patent crossed into clear criminal fraud. She's being charged with wire fraud and making false statements to federal agencies. Those are felonies. I sat down heavily in my kitchen chair. This had gone from a neighborhood nuisance to federal criminal charges. Part of me felt vindicated, but another part felt overwhelmed by the magnitude of what had unfolded. The arrests happened 3 weeks later. I was at work when Marcus texted me a link to a Chicago Tribune article with the headline, "FBI Arrests Executives in HOA Intellectual Property Theft Scheme." The article detailed the charges against Premier Community Services and named Patricia Morrison among 7 HOA board members across multiple states facing criminal charges. My phone started ringing almost immediately. Friends and neighbors who had no idea what I'd been dealing with called to ask if I was okay. A few people apologized for not believing me when I'd mentioned the HOA harassment months earlier. 2 reporters requested interviews, which Daniel advised me to decline until after the criminal proceedings were complete. The preliminary hearing for Patricia's case was scheduled for late April. Daniel and I attended as witnesses. The courtroom was packed with media and other residents from premier managed communities who had their own stories of HOA overreach. Patricia looked diminished in her defendant's chair, a far cry from the confident, imperious HOA president who had demanded my formula 9 months earlier. Her attorney, a public defender named Richard Walsh, looked like he was going through the motions. The evidence against her was overwhelming. The prosecution laid out their case methodically. They showed the original demand letter for my formula, the bogus violations issued in retaliation, the fraudulent cease and desist letter claiming HOA ownership of my patent, and emails between Patricia and Todd Vickers at Premier discussing how to acquire valuable resident IP assets for community benefit and potential revenue generation. The last part was particularly damning. The emails made clear that Patricia hadn't just been on a power trip. She'd been trying to steal my patent with the explicit goal of licensing it for profit, with revenue to be split between the HOA and Premier Community Services. Judge Amanda Foster, presiding over the preliminary hearing, looked disgusted as she reviewed the evidence. "Miss Morrison, do you understand the severity of the charges against you?" Patricia's voice was small when she answered. "Yes, Your Honor. You attempted to misappropriate a federally registered patent through fraud and coercion. You filed false legal claims asserting ownership of intellectual property you knew belonged to someone else. You coordinated with a management company to systematically identify and exploit residents in your own community." Judge Foster shook her head. "I'm binding you over for trial on all charges. Bail is set at $50,000. Patricia's face went pale. Her attorney requested a lower bail amount, but Judge Foster was unmoved. As we left the courthouse, Daniel seemed satisfied. "That went well. The judge is clearly taking this seriously. Do you think she'll go to prison?" "Almost certainly. Wire fraud alone carries up to 20 years, though she probably won't get anywhere near the maximum. More likely she'll be looking at 3 to 5 years plus restitution and fines." He glanced at me. "How are you feeling about all this?" I considered the question. "Honestly, exhausted. I just wanted to use my own product on my own driveway. I never imagined it would end up here. That's the thing about standing up to bullies. Sometimes you discover they are part of something much worse than you realized." The criminal trial took place in July. I testified for 3 hours, walking the jury through the entire timeline from the initial demand letter through the fraudulent patent claims. Marcus testified about the impact on our business, including the financial losses from retailers dropping our product during the dispute. Special Agent Crawford testified about the broader investigation into Premier Community Services and the pattern of IP theft they'd uncovered. The most compelling evidence was the email trail between Patricia and Todd Vickers. The prosecution projected them on large screens for the jury to read. The emails showed clear intent to steal my patent and profit from it. One email from Patricia to Todd read, "If we can secure the Thompson formula, conservative estimates put licensing revenue at $200K, $300K annually. This could fund community improvements for years." Todd's response was equally damning. "Great thinking. Remember, the key is establishing that anything developed while residing in the community constitutes a community asset. Make sure your bylaws are updated to reflect this before you make your final push." Except there was one problem with their plan. I developed the formula before I moved to Pine Ridge, and bylaws can't retroactively claim ownership of existing intellectual property anyway. Their entire scheme was built on fraudulent legal theories. The jury deliberated for less than 4 hours. When they returned, Patricia stood with her attorney as the forewoman read the verdict, guilty on all counts. Patricia's sentencing hearing was scheduled for September. In the meantime, my civil lawsuit against her and the HOA moved forward. With Patricia's criminal conviction, the civil case became much simpler. The HOA's insurance company, desperate to avoid a lengthy trial, offered a settlement of $375,000. Daniel advised me to take it. You could potentially get more at trial, but this is a solid offer. It covers all your legal expenses, compensates you for the business losses, and provides substantial damages for the harassment you endured. I accepted the settlement. The money was transferred to my account in October, just before Patricia's sentencing hearing. Judge Foster showed no leniency at sentencing. She sentenced Patricia to 4 years in federal prison, followed by 3 years of supervised release. She also ordered Patricia to pay restitution of $115,000 to me personally, covering my documented business losses and additional legal expenses not covered by the HOA settlement. Miss Morrison, you abused a position of trust to attempt theft of valuable intellectual property, Judge Foster said. You engaged in systematic harassment of a member of your own community for your own financial gain. This court cannot and will not tolerate such behavior. The sentence reflects the seriousness of your crimes and serves as a deterrent to others who might consider similar schemes. Patricia was led out of the courtroom in handcuffs. I felt no satisfaction watching her go, only relief that it was finally over. The fallout from the case extended far beyond Patricia's conviction. Premier Community Services collapsed under the weight of the criminal charges and civil lawsuits. 43 HOAs suddenly found themselves without management, and several had to declare bankruptcy due to lawsuit settlements. Todd Vickers and 2 other Premier executives were convicted of conspiracy and sentenced to prison terms ranging from 6 to 8 years. As for me and Marcus, our ice melt business actually benefited from the publicity. The story got picked up by major media outlets, and the ice melt product that an HOA tried to steal became a compelling marketing angle. Orders increased by 340% over the following year. We expanded distribution to 6 additional states and had to contract with a larger manufacturing facility to keep up with demand. I moved out of Pine Ridge in December, purchasing a beautiful house on 2 acres in unincorporated DuPage County with no HOA in sight. The property had a long driveway that I could cover in my ice melt every winter without anyone demanding to know my formula. The new Pine Ridge HOA board, elected after Patricia's removal, sent me a formal apology letter and offered to refund 5 years of HOA dues as a gesture of goodwill. I accepted the refund but declined their invitation to rejoin the community leadership. Some bridges are better left burned. One afternoon in January, nearly 2 years after the initial demand letter, I was spreading my ice melt on my new driveway when my neighbor from across the street walked over. His name was Robert Franklin, a retired engineer who had introduced himself the day I moved in. "That's remarkable stuff," he said, watching the ice literally disappear on contact. "What's in it?" I smiled. "It's a proprietary formula, patented actually." "Ah, say no more." "I respect intellectual property." He paused. "Though if you ever want to sell me a few bags for my driveway, I'd be happy to pay whatever you're charging." "I can do better than that," I said. "Let me give you a bag as a housewarming gift from me to you. No strings attached." Robert's face lit up. "That's very generous. Thank you." As he walked back to his house with the bag of ice melt, I reflected on how much had changed. I defended my intellectual property, stood up to harassment, and inadvertently helped expose a criminal conspiracy. The journey had been exhausting and expensive, but it had been worth it. My phone buzzed with a text from Marcus. Just signed a deal with a national hardware chain. They want to carry our product in 347 stores starting next quarter. We did it, partner. I typed back. Never doubted it for a second. That wasn't entirely true. There had been plenty of moments during the legal battle when I doubted everything. But standing in my new driveway, watching the winter sun reflect off the clear pavement where ice had been minutes before, I felt something I hadn't felt in a long time. Peace. The patent plaque I'd received from the USPTO hung in my home office, a reminder of the 4 years of work that had gone into developing something genuinely innovative. Patricia Morrison had tried to take that from me, tried to claim credit for my hard work and ingenuity. She'd failed spectacularly, and in the process, she destroyed her own life and exposed a criminal enterprise that had victimized dozens of other people. I didn't take pleasure in her downfall, but I didn't regret fighting back either. Some battles choose you, whether you want them or not. When someone tries to steal your work, your creativity, your innovation, you have to stand your ground. The alternative is letting bullies and thieves win. That evening, I video called my parents in Arizona to catch them up on the latest business developments. My mom, Teresa Richardson, had been worried sick during the entire legal ordeal. My dad, Kenneth Thompson Sr., had been my rock, constantly reminding me that we came from a long line of people who didn't back down from fights worth fighting. "I'm proud of you, son," he said on the call. "You stood up for what was right, and you did it the right way, through the courts, through proper legal channels. That takes strength." "It took a lot of money too," I said with a laugh. "Thank God for that settlement." "The money comes and goes," my mom said. "What matters is you didn't let them break you." Patricia Morrison thought she could intimidate you into giving up your patent. She thought she could bully you because she had the HOA behind her. She was wrong. They were right. The money had been substantial, both lost and eventually regained, but the real victory was standing up to systematic harassment and refusing to surrender what was rightfully mine. A few weeks later, I received an unexpected letter from the USPTO. They were featuring my case in a bulletin about protecting intellectual property rights against unconventional forms of theft. The bulletin would be distributed to patent holders across the country as an educational resource about defending their rights. Your successful defense of your patent rights against HOA overreach serves as an important example for other inventors and patent holders, the letter read. Your case helped expose a criminal conspiracy and may prevent similar theft schemes in the future. I framed the letter and hung it next to my patent plaque. In March, I was contacted by a reporter from a popular business podcast who wanted to interview me about the case and the ice melt product. Daniel approved the interview, and I spent an hour talking about the technical development of the formula, the patent process, and the bizarre twist of having an HOA try to steal it. The podcast episode was downloaded over 200,000 times in the first week. I received emails from other patent holders who had faced similar pressure from HOAs, employers, or business partners trying to claim ownership of their work. Several asked for advice or referrals to intellectual property attorneys. I started connecting people with Daniel, who was happy to consult with other inventors facing IP theft attempts. He told me later that 3 of the referrals had turned into significant cases, including one involving a software engineer whose employer tried to claim ownership of a smartphone app. The engineer had developed entirely on his own time. The ice melt business continued to grow throughout the year. By December, we were projecting annual revenue of just over $2 million. Marcus and I hired 3 full-time employees to handle logistics, sales, and customer service. We moved into a small office space in Naperville, transforming from a side business into a legitimate company. I never forgot the lesson Patricia Morrison inadvertently taught me. Your work, your creativity, and your innovations are worth fighting for. When someone tries to take what you've built, you have every right to defend it with everything you've got. On a cold Saturday morning in February, I was spreading ice melt on my driveway when a car pulled up. A woman I'd never seen before got out, looking nervous. "Are you Keith Thompson?" she asked. "I am. Can I help you? My name is Sarah Mitchell. I live in a neighborhood in Aurora, and our HOA just sent me a letter demanding that I turn over the source code for a gardening app I developed. I saw your interview on that podcast, and I was hoping you could give me some advice." I invited her inside and made coffee while she explained her situation. It was eerily similar to what I'd experienced: an HOA overstepping their authority, demanding proprietary information, and making thinly veiled threats. I gave her Daniel's contact information and walked her through my experience, emphasizing the importance of documentation and immediate legal response. She left looking more confident, armed with information about how to protect her intellectual property. After she drove away, I realized that my experience had given me a kind of expertise I'd never anticipated: how to fight back against HOA overreach and protect intellectual property from unconventional theft attempts. I decided to write a detailed guide about my experience and publish it online. Over the next few weeks, I compiled everything I'd learned into a comprehensive resource covering the legal framework for defending patents, documenting harassment, working with IP attorneys, and understanding when HOA demands cross into illegal territory. I published the guide on a website Marcus helped me set up. Within a month, it had been viewed over 15,000 times. I started receiving thank you emails from people who had used the information to fight back against their own HOA disputes. One email came from a man in Wisconsin named Thomas Turner, who had developed a specialized solar panel coating. His HOA had claimed that any energy efficiency improvements developed within the community belonged to the association. Using my guide and Daniel's contact information, Thomas successfully fought the claim and retained full ownership of his patent. He later licensed the technology to a major solar company for substantial royalties. Stories like Thomas's reminded me that Patricia's attempt to steal my patent had consequences far beyond our personal conflict. The case had set precedents, exposed criminal activity, and helped other inventors protect their work. In a strange way, Patricia had done me a favor by fighting so aggressively and so illegally. If she'd backed down after the first court ruling, Premier Community Services might still be operating their IP theft scheme, and dozens of other inventors might have lost their work. In May, I was invited to speak at a small business conference in Chicago about protecting intellectual property. The audience consisted mostly of entrepreneurs and inventors, many of whom ran businesses from home or had developed products in their spare time. I shared my story and emphasized the importance of proper patent protection, documentation, and immediate legal response to any threats. During the question and answer session, a woman in her 30s raised her hand. "How did you stay motivated during the legal battle?" "I'm fighting my own IP dispute right now, and some days I just want to give up." I thought carefully about my answer. Honestly, there were days I wanted to give up too. The legal fees were mounting, the stress was affecting my health, and it felt like the system was rigged against individual inventors. But then, I'd remember why I developed the formula in the first place. I wanted to create something better than what existed, something that would genuinely help people. Patricia Morrison didn't create that. She didn't spend 4 years researching and testing. She didn't invest her own money or take any risks. She just wanted to steal the results of my work. Once I framed it that way, giving up wasn't an option. The room was silent for a moment, then erupted in applause. After the conference, 7 people approached me privately to share their own stories of IP theft attempts and to thank me for speaking publicly about my experience. Driving home that evening, I realized I'd found an unexpected purpose beyond just running a successful business. I'd become an advocate for inventors and small business owners facing intellectual property theft. It wasn't a role I'd sought out, but it was one I was uniquely qualified to fill. The 1-year anniversary of Patricia's conviction came and went quietly. I marked the date by making a donation to a legal aid organization that helped small inventors with patent applications and IP protection. If my experience had taught me anything, it was that not everyone could afford the kind of aggressive legal defense I'd been able to mount. Many inventors surrendered their work simply because they couldn't afford to fight. By the fall, Marcus and I were in discussions with a potential investor who wanted to help us expand nationally. The ice melt business had proven successful beyond our initial projections, and the brand recognition from the lawsuit publicity had opened doors we never could have anticipated. "It's ironic," Marcus said during one of our planning meetings. "Patricia trying to steal your formula ended up being the best marketing we could have asked for. Obviously, I'd never recommend going through what you went through, but the publicity genuinely helped." He was right. The story of the HOA trying to steal a patent had resonated with people far beyond the usual audience for de-icing products. It had become a story about standing up to bullies, defending your rights, and refusing to be intimidated. Those themes were universal. In November, I received notification that Patricia Morrison had been released from federal prison after serving 18 months of her 4-year sentence. She'd been granted early release for good behavior and was now under supervised release for the remainder of her sentence. I felt nothing when I read the notification. No anger, no satisfaction, nothing. Patricia was part of my past, a cautionary tale about what happens when power goes unchecked and greed overrides ethics. Her life had been permanently altered by her choices. My life had been temporarily disrupted, but ultimately strengthened. The house in unincorporated DuPage County had become my sanctuary. 2 acres of property with no HOA, no busybody neighbors demanding to inspect my garage, no violations for imaginary infractions. I could develop products, run my business, and live my life without constant interference. On Christmas Eve, I hosted a small gathering for close friends and business associates. Marcus was there with his wife Jennifer, Daniel came with his partner Stephen, and several of our new employees attended with their families. We gathered in my spacious living room, enjoying good food and better company. At one point, Marcus raised his glass. "I want to propose a toast to Keith. 2 years ago, he was being harassed by a petty HOA president who thought she could steal his work. Today, his product is in over 400 stores across 9 states. He's helped expose a criminal conspiracy, and he's become an advocate for other inventors." That's the definition of turning adversity into opportunity. Everyone raised their glasses and cheered. I felt genuinely grateful for the people in that room, the ones who had supported me through the nightmare and celebrated the success that followed. Later that evening, after most of the guests had left, Daniel and I stood on my back porch watching snow fall gently across the property. "You ever regret fighting back?" he asked. "If you just ignored Patricia's initial demand, none of this would have happened." I considered the question seriously. If I'd ignored her, she would have escalated anyway. People like Patricia don't stop when you give in. They see surrender as weakness and push harder. Fighting back was the only option that had any chance of ending the harassment. "True," Daniel agreed. "And if you hadn't fought back, Premier Community Services would still be operating their IP theft scheme. Who knows how many other people they would have victimized?" That perspective had helped me make peace with the entire experience. Yes, it had been stressful and expensive and time-consuming. But it had also mattered. Standing up to Patricia had exposed a criminal conspiracy and helped protect other inventors from similar theft. As 2025 turned into 2026, the ice melt business continued to thrive. We signed the deal with the national investor, secured distribution agreements in 12 additional states, and began development on a second product. A pet-safe sidewalk de-icer with an even gentler formula than the original. I maintained the website with resources for other inventors, regularly updated with new information about protecting intellectual property and fighting HOA overreach. The site had grown to include a forum where inventors could share their experiences and advice. Several attorneys, inspired by Daniel's work on my case, volunteered to answer legal questions on the forum. In March, I received an unexpected email from Gary Williams, one of the former HOA board members who had sat behind the defense table during that first injunction hearing. He'd resigned from the board immediately after Patricia's arrest and had apparently spent the past 2 years reflecting on his role in the situation. "Mr. Thompson," the email read, "I know this email is long overdue and I don't expect you to respond. I wanted to apologize for my part in what happened to you. I was on the HOA board with Patricia, and while I wasn't the one pushing for your formula, I didn't speak up against it either. I let her push through those bogus violations, and I stayed silent when I should have objected. You deserved better from your community leadership, and I failed you. I'm genuinely sorry, and I'm glad you fought back and won. Your courage exposed problems that needed to be exposed. I hope you're doing well." I read the email several times before responding. Gary's apology seemed genuine, and he'd suffered consequences too, his reputation in the community destroyed by association with Patricia's crimes. I wrote back, "Gary, I appreciate you reaching out. What happened was wrong, but I understand the pressure Patricia put on people around her. The important thing is that you recognized the problem and took responsibility. That takes courage too. I wish you well." His response came within an hour. "Thank you for your grace. It means more than you know." The exchange reminded me that most people caught up in situations like mine weren't villains. They were ordinary people who made bad choices or failed to speak up when they should have. Patricia had been the driving force, the true bad actor, but she'd been enabled by people who should have known better. As spring arrived, bringing warmer weather and melting the last of the winter ice, I reflected on how much my life had changed in just over 2 years. I'd gone from being a harassed homeowner to a successful business owner and reluctant advocate for intellectual property rights. My ice melt formula, the thing Patricia had tried so desperately to steal, had become the foundation for something larger than I'd ever imagined. Standing in my driveway on a warm April morning, watching the sun rise over the trees that bordered my property, I felt profoundly grateful. Grateful for the freedom to live without HOA interference. Grateful for the business success that had exceeded my expectations. Grateful for the legal system that had ultimately protected my rights. And grateful for the strength I'd discovered when I'd been forced to fight back. Patricia Morrison had demanded my ice melt formula, not knowing it was patented under my name. That ignorance, that assumption that she could take whatever she wanted from people she saw as beneath her, had been her downfall. She'd underestimated me, underestimated the law, and underestimated the consequences of her actions. I never set out to be anyone's hero or cautionary tale. I just wanted to use my own product on my own property. But when pushed, when threatened, when someone tried to steal what I'd worked so hard to create, I discovered reserves of determination I hadn't known I possessed. The ice melt formula was mine. The patent was mine. The business success was mine. And no HOA president, no matter how entitled or aggressive, could take that away. That was the real victory. Not the settlements or the criminal convictions or the business growth, though those were all significant. The real victory was knowing that I'd stood my ground, defended what was mine, and refused to let a bully win. As I headed inside to start my workday, my phone buzzed with a message from Marcus. New order from Home Depot. They want to expand our shelf space in 127 stores. This is huge. I smiled and typed back, "Let's do it." The ice melt that Patricia Morrison had tried to steal was now helping hundreds of thousands of people safely navigate winter weather across multiple states. The formula she'd claimed belonged to the HOA was generating millions in revenue and creating jobs. The product she'd thought she could simply take was thriving specifically because I'd refused to surrender it. Sometimes the best revenge isn't revenge at all. It's success. And as I sat down at my desk to review the new Home Depot contract, I realized I'd achieved something Patricia never could have. I'd built something genuinely valuable through hard work, innovation, and integrity. My ice melt formula would continue protecting driveways and sidewalks for years to come. My business would continue growing and creating opportunities. And my story would continue serving as a reminder to inventors everywhere that intellectual property rights matter, that fighting back against theft is worth it, and that sometimes the bullies don't win. Patricia Morrison demanded my ice melt formula. She didn't know it was patented under my name. That ignorance cost her everything. My refusal to surrender cost me plenty in stress and legal fees, but it earned me something far more valuable, the knowledge that when it mattered most, I'd stood up for myself and won. That was worth more than any formula could ever be.